Good morning, everyone. Good morning, everyone. I'm just going to wait for you guys to tune in. I've missed you guys. I haven't been on so much this week. It's just been a hectic week for me. The week back, after the holidays is usually super busy. But say hi. I can see you all coming in. Good morning, Facebook. Good morning, TikTok. Good morning, YouTube. Good morning, Instagram. Good morning, Mario from New York on Instagram. Thank you for tuning in. Good morning, Latoya. Good morning, Joy on Facebook. Good morning, Novalette on Facebook. Good morning, guys. If you've missed me, put a hands up in the comment. I know I've been incognito. I don't think I've come on live this week. Maybe I came on live on Monday. I don't remember, but it's just been a really, really busy week. Top of the morning, Popfly on Instagram, Ade from Newark. Good morning, Kevy, Mario. Okay, guys, let me introduce myself. If this is your first time tuning in, my name is Aisha Chidole. I'm an immigration attorney out of Orlando, Florida area, but I represent clients in all 50 United States with the immigration matters. So whatever or wherever you live, it doesn't matter. If you are trying to immigrate to the United States and it's family related, I'm happy to help you. My phone number is 407-995-6567. And my WhatsApp, if you want to send us a text message on WhatsApp, it's 404-333-8751. You can check my profile. I think that's the number. So today, happy new month, by the way, to everybody, and happy December. Can you believe it? 2021 is almost over. It's almost over. And hopefully 2022 will be a blessed year for everybody, and all good things, all good things. So today I want to talk about what your options are, as far as getting a green card if you entered into the United States. Two categories I'm going to talk about. I'm going to talk about if you came into the United States legally. When I say legally, you came in with a visa that allowed you to be in the United States. And if you came into the United States illegally, when I say illegally, I mean like you either crossed the border, you entered without inspection, or you came on a transit visa and you didn't go wherever you were going. And a transit visa, for those who don't know, are things like a crewman visa, like a C1, C2 visa, stuff like that. So for those who have come into the United States with visas that allow them to be, so like you came here on a B1 visa, which could be like a business or a visiting visa, or you came here on an H2B visa, or you came here on an F1 visa. And sometimes a J1 visa. How you can stay here and adjust your status is usually through a family basis, or something happening to you that's not good. So let's first start with family basis. When you are in that category, and when I'm talking about overstay, I am talking about meaning your visa had expired and you stayed in the United States after the date of expiration on your I-94. A lot of times people say, well, I have a 10-year visa. So when the US is looking at overstay, they're not looking at how long you have a visa. They're looking at that time that you entered into the country. What does your I-94 say? Does your I-94 say you have 6 months in this country and you need to leave within the 6 months? So whether you have a 10-year overall visa, it doesn't matter. If you were only supposed to be here 6 months, after that 6 months, overstay is when you'll be an overstay. So the categories that will forgive you for an overstay is one, if you are married to a US citizen. If you are married to a US citizen, you will be considered an immediate relative, and so you will have priority, which means that you can overstay, or you can adjust your status while you're here in the United States and become a US citizen. I mean, a green card holder and eventually a US citizen, even though you had overstayed your visa. The second category is if you have a child who is a U.S. citizen that is over the age of 21 that petitions for you. If you have a child who's in that category, they can petition for you even if you've overstayed your time here. Okay. The third category is if you are a child, a minor under 21, and your parent is a U.S. citizen. You notice I didn't say that your parent is a green card holder. Your parent is a U.S. citizen. You will be an immediate relative and they can petition for you. Now, if you do not fall into those categories, another option, if you qualify, is if you are married to a U.S. citizen or a green card holder and your spouse is abusive to you. If you're U.S. citizen, green card holder spouse, or your green card holder or U.S. citizen spouse is abusive to you and you've overstayed your time, you can adjust your status and get a green card. This exception also applies if you entered into the United States without inspection. The exception also applies if you came into the U.S. with the C1, C2, crewman visa. The exception also applies, what other category am I missing? So basically it applies when you basically came, you crossed the border, you entered without inspection, or you came with a transit visa. So you can still adjust your status. And this is very different from, say, you're married to a U.S. citizen and everything is going well. If you're married to a U.S. citizen and everything is going well, but you came into the country without inspection. And whenever I say without inspection, what I mean is you came in without anybody reviewing any documents to let you in. If that's the case, usually you cannot adjust your status. What will happen is your spouse can file an I-130, and then when that I-130 is approved, you will then file for what we call a hardship waiver. Basically, your spouse will have hardship, if you were not allowed back into this country. When that hardship waiver is approved, then you can leave the country, attend your interview, and hopefully be granted a green card, and then you can come back. But otherwise, those two categories, crewman category, entry without inspection, you will not be able to adjust your status based on a regular marriage. Now, what if you overstayed and you're married to a green card holder? If you overstayed and you're married to a green card holder, you're not eligible to adjust your status either. So there is a group called family preference category. I always try my best to find like layman's terms, like an easy way to explain some of these legalese, to you guys, to simplify it for you. But, so like the first half of this 8 minutes, I just talked about people that they consider your immediate relatives, so husband, wife, parent, child, right, as U.S. citizens. Now, there's another group of people that even though for biology's sake, they're your immediate relative, for immigration purposes, they're just what we call family preference category. So they don't look at them as your immediate relatives, so visas are not immediately available. In those categories, i.e., if you are a green card holder and your spouse overstays their time here, you will not be able to file for them for an adjustment of status. Again, you can file the I-130, but they're going to need a waiver, or you're going to need to become a U.S. citizen. When you become a U.S. citizen, then you can adjust your application, or they will need the waiver approved, and then they have to go back to their home country. It applies as well if you're petitioning for your siblings. So if you're petitioning for a sister or brother, first of all, apart from the fact that the timeline is like 15 to 16 years, they still cannot have overstayed their time here. So if you're petitioning for somebody that lives here, they surely would have overstayed their time by 15 or 16 years, because most of the times it's 6 months. Okay. Same thing applies for green card holders filing for their children. Two categories of children you can file for as a green card holder: those under 21 and those over 21 that are unmarried. Because remember, green card holders cannot petition for children that are married. Okay. Okay, I will answer your question. In that category as well, they cannot adjust their status while they're here. They cannot get a green card while they're here. They have to get the hardship waiver. If your child, as a green card holder, is under 18 and overstayed their time here, right? While they cannot adjust their status here, they will need a hardship waiver because they're minors, and minors cannot accrue unlawful presence. The way USCIS sees it is that is a parent's decision. The minor didn't make that decision for themselves, so they shouldn't be punished for that decision. So this is a little bit of a summary. It's a bit complex, but it's a little bit of a summary of who can stay, who can't stay. What you need to remember, the catch-all is, if you're married to a U.S. citizen, generally you can get a green card while you're in the United States. If you're married, if your parent is a U.S. citizen and you're under 21, you can stay and get your green card. If your child is over 21 and a U.S. citizen, you can stay and get your green card. If you're a VAWA victim, you can stay and get your green card. And let's see what other options. And then there is something also called a T visa, but that's a different topic. Maybe I'll talk about that in my next topic. T visas are for people who deal with like human trafficking. And so if you are human trafficked, or for either as a sex worker, or sometimes there's human trafficking in like hair braiding salons, and like they get all these girls, and basically pay them like sweatshop labor while they're there sweating and toiling and braiding hair. Like, those are all things that could also still qualify you if you came into the country without inspection to get a green card. I can talk about that in another post. Okay, so let me answer some of your questions. Hi, Seven. Hi, Olamide. I am doing good, thank you. Hi, Sandra. Tiffany says, what if your fiance is a TPS holder? The TPS holder is marrying a U.S. citizen. Is that a simple adjustment of status? Believe it or not, there's no such thing as a simple adjustment of status, because your TPS holder, we need to know, with your TPS holder, are they in removal proceedings? Did they how did they come into the country? Because there are new rules that changed this year that makes it a bit more complex. But the most important thing is determining if the removal proceedings, did they file asylum, and was the asylum not granted, and then they referred them to an immigration judge. All those things change as far as who can adjust your status, and how you can get a green card holder, how you can get a green card. Good morning, Macedonas from Washington. Good morning, Stephanie, on Instagram. All right, let me see if there are any questions on Instagram. Adelove says he's in removal. I don't do removals, so I can't answer your question. Somebody says, thanks for what you're doing, bringing joy and unity to families. Thank you, I appreciate it. Okay, so do you guys have any other questions for me before I jump off? I'm going to wait a few minutes to see if there are any questions. I'm going to jump off. Let's see. Okay. My question is, what time do you apply for your U.S. citizenship? How many years do you need to be in a marriage? So the answer depends on if you're still in the marriage or if you're divorced. If you're still in the marriage, you can apply for your U.S. citizenship within 3 years. You have to be married for 3 years, and you have to have had your green card for 3 years. So typically the earliest would be like 2 years and 9 months is when you can put in your application. Basically 90 days to your 3-year green card application, green card anniversary. Now, if you're not married, you're divorced, or you didn't get your green card through marriage, then you have to wait 5 years. Same thing as with the other one, you have to put in your application at least 4 months, 4 years and 9 months before the 5th year. And also keep in mind, you still have to meet the other requirements for naturalization, like traveling. If you're traveling a lot, you want to tabulate how long you've traveled to make sure you meet the travel requirements, and keep in mind that if you travel and you traveled for more than 6 months. Basically, you've broken continuity and you're essentially restarting your counting. You want to make sure that you're paying your taxes. If you got baby mamas, baby daddies, and basically you don't have custody of your children, you want to make sure that you're paying child support and you have proof and evidence of that you're paying child support. If you don't do that, you're going to get denied. You want to make sure that you're paying taxes. If you owe taxes, you want to make sure that you have a payment plan. You also want to make sure that you're not creating your payment plan when you are submitting your application, because what they're going to say is that, oh, you were not paying your taxes and all of a sudden you want to file for naturalization and now you think, you're going to do it. So they will say you don't have good moral character. They also look at crimes of moral turpitude, and usually they go back 5 years most of the time, even though they have the discretion to go back further, but generally that's around the period they look at. So those are all things that you have to make sure, you're good with, basically, before you do that. Okay, so someone says, if they tell you by USCIS to wait for your answer in 180 days, what does that mean? It means that, well, what did they tell you? Who told you that? Who told you to wait 180 days? And what are you waiting for? Okay, let's see. How waiver take for you to get your green card? Are you saying how long will the waiver take? Is that what you're asking me? So the first thing is, obviously you apply for your I-130, and your I-130 could be approved 6 to 12 months, just a general estimate. Sometimes it could be quicker, sometimes it could be longer, but let's just say 6 to 12 months. Then you finish that and, you pay your NVC fees, then you apply for your 601A waiver, and then that could take anywhere from another 8 to 12 months. And then when that's approved, then, you deal with scheduling of your interview, however long that's going to take in your home country. So give or take, with the waiver application, it's going to be a bit longer, and it could take from the time you start till the time you finish 2 to 3 years. Again, when I give you guys this timelines, it doesn't mean that that is what yours would be. Yours could be quicker. Yours could fall in the middle of the timeline. Yours could be longer. Every case is different, but it's just an estimate. But when you do a waiver, expect that it's going to take you at least 2 years to start and finish the process. Okay. Please, ma'am, can someone transition to EB2 procedure while being an asylum application prior to your hearing, and how long does that take? So I don't handle employment-based green cards, but the answer is no. Though, but I don't handle an employment-based green cards, because generally, like I told you, the only category in which you can adjust your status is what I mentioned earlier. If you are outside of the time that you need to be. Otherwise, you must leave the country and come back. Employment-based cases, you must be in legal status. You must be in legal status to get an EB1, EB2, EB3, EB5. You must be in legal status. Okay. Alameda says, can you please help me get a visa for my wife to visit me in Nigeria? We don't handle visiting visas. We only handle like green cards and getting your citizenship. Your Connected says, how much do you charge for a VAWA case, or can I do it myself? Well, you can definitely schedule a consult with us, and we can go over the process and the fees. We actually have a 30% cyber week that is ending tomorrow right now. So it's a good time to call 407-995-6567. Latoya says, how long does a VAWA for children take to get through? It's the same time. So, it takes anywhere from 24 months to 2.5 years for a VAWA case, whether it's children, whether it's parents, or whether it is spouse. The only thing is that, while it's pending, within 5 to 8 months, you get your work permit and your travel permit. So, while your case is pending, at least for 2 years of that time, you're able to work, you're able to travel. But sometimes it could be, it could be 18 months. So it's, again, when I say timelines, it's not a definitive, it's just what an estimate is. Okay. Can a non-citizen invite someone into the United States? What do you mean a non-citizen? Like, are you a green card holder, or are you here illegally, or are you here um, as an overstay? Is that what you mean? So the question is too vague. Okay, so somebody says, my cousin has three American born citizen children, age 12, 9, and 4. One of the kids has special needs. Now she's thinking of relocating to the States. Can her kids file for her? So children cannot file for their parents until until the children are over 21. So the earliest that any of them would be able to file for her is 9 years from now. Um, but if she was in the United States and her child has special needs, there actually is something called a medical deferred action that she can be eligible for if she was in the United States, which is if that child needs her as her primary caregiver, and we've had, some success with this actually, and we'll be able to help them, but they have to be here. Okay. Um, Julian says, can you explain to me how this works? If you were denied a green card and now you're divorced, can you still apply for your green card? Well, it depends. In order to determine if there's something else that would qualify you for a green card, we definitely have to schedule a consultation so we could go through, an analysis of basically you and what options are available to you. And I'll be happy to do that with you. You can schedule a consult with me for 7995657. You're so pretty. Love from your client in New York, Leon. Hi, Leon. Oh my God, who's this? This person has the same last name as me. That is so random. The same Onyakwelu Ifi, the person that I just waved at, that's actually my maiden last name. Is that somebody I know? If you're somebody I know, comment in the box and let me know. We have the same last name. Unfortunately, I don't handle deportation, HLM at a love. I just don't, sorry. So I can help. I'm sorry. Let's see what else. Titus says, how can you expedite advance parole? So how you can expedite as advance parole is if there is a true emergency, or what USCIS considers a true emergency. And usually you want to go to, you would have to request an info pass and go to the USCIS office yourself. Present your true emergency. So documentation, like God forbid, if somebody passes away, someone's on their deathbed, their familiar relation to you, but you have to have evidence of that. And they will have to say, okay, this is an emergency. We're going to expedite and allow you to travel and come back. So that's how you do it. Okay. Okay, I see what you're saying. So after the interview, they requested evidence, and after evidence was received, they advised that you'll receive your answer after 180 days. Does it mean a denial? No, it doesn't mean a denial. It just means that they're reviewing your evidence. And if they determine that it's not good enough, they will send you a notice of intent to deny, or deny your case based on, what it was at. Because I don't know if they sent you a notice of intent to deny, or if they sent you an RFE, or what it is. So, Yolanda says, if you overstayed your visit and married to a green card holder, can he petition for you? Yolanda, did you just log in? I just talked about this. So you should watch this video back over again. I just talked about it. But the short answer is it depends. Actually, it depends. If you overstayed and the person is a green card holder, they can petition your I-130, but not for you to get your green card, or for you to get your work permit and travel permit, until they become a citizen. So the quick answer is no, not with this category. However, if they're eligible to become U.S. citizens, and while they're in the process of becoming U.S. citizen, they file for your I-130, and then they become citizens, they can then do the adjustment for you. So that is the quick answer. HM Love. Because I don't know your case, and what's going on in your case, I can't give you any advice, and I don't give legal advice, on live. I just answer general questions. You can definitely call and schedule a consultation, but I don't do removals, so you're probably best finding an immigration attorney that does removal proceedings, if you are about to be deported. Okay. Crystal says, "Good morning. Can a 10-year green card holder stay out of the country for a year without being penalized? My friend wants to stay in Jamaica for a year to take care of his 9-year-old mother. He has been there for 4 months already. He better get his behind back." I'm just kidding, but yeah, you'll be penalized. They're going to say basically that you abandoned your green card, and if he has nobody else to petition for him, then he will lose his green card forever. Now, if let's say you got your green card through your children, or something like that, and you lost your green, you're out there, and it's been over a year, and you come back, obviously they're gonna seize your green card. Your children can certainly file a new one for you, but there definitely will be some hefty penalties. So if he can come back before the 6-month mark and then maybe go back, like stay here for a month and then go back, that'll actually be better as opposed to just being, excuse me, gone for a full year on island. The good thing is that Jamaica is not like too far away from the US where, they're able to do that. Okay. Let's see. You're connected says Merry Christmas. Merry Christmas to you too. Christmas is my personal favorite holiday. I don't know what y'all's favorite holiday is. I decorate, I do the whole Christmas shebang, elf on the shelf with my kids. Growing up, my mom really tried to do up Christmas for us. So I always have happy memories during Christmas, and I try to do that for, my people as well. Okay. Um, my friend is in Nepal, but her husband passed away in the United States. He was a US citizen. What is her option? They have a 2-year-old baby. Well, first of all, I'm so sorry to hear that. That's really sad. But she could be eligible for a widow petition to get her green card as a widow. So I'll be happy to consult with her just to see when they got married, what proof she has they got married, but she can do like a widow petition. Jillian says Christmas is her favorite holiday as well. Awesome. Um, Boo for the Bula says, can you give details on filing for VAWA and on deportation? Okay, so basically, similar to when you submit an I-130, when you're in deportation, you can file for VAWA while you're in deportation. However, you're going to have two options for the final product. So as you guys know, when you submit a VAWA application, there are two steps to approval. First, your VAWA has to be approved, then your green card has to be approved. If you are in deportation, once your VAWA is approved, there are a few things that can happen. You and the government, when I say you, meaning your attorney and the government, can do a joint motion to terminate, where they basically ask the judge, can you terminate this deportation because this client has relief because they have an approved VAWA so that they can do the adjustment, or if they don't, then they can just do your adjustment within the court. So yeah, submitting your actual VAWA petition while you're in removal is helpful, if you get approved. Okay, so let's see what other questions I have. Merry Christmas. You look so amazing. Looking at you brings hope for the hopeless. Thank you for all you do. Thank you so much. That's so sweet of you. I appreciate it. Who's calling me right now? Sorry, I'm on live. Okay, let's see what else I have here. All right, what other questions do you guys have? Can you guys hear me? Yeah, I'm sorry. It went silent because somebody's like blowing up my phone. Can you guys hear me on Instagram? Still not hearing me? Can you guys hear me on Instagram? That is so annoying. Like, who is calling me right now? Can you guys hear me on Facebook? You still can't hear me? Okay, I'm gonna come back on live. And on Instagram. Okay, IG, comment in the box. Can you guys hear me? Let's see if they can hear me on IG. Sorry, Facebook and YouTube. Just give me a minute to see if I can fix this. If you're on Instagram, if you can hear me, can you comment? If you can't hear me, comment as well. Let me know. Otherwise, okay, you can hear me now. Good. So I obviously X'd out, so I've lost all the questions that you guys were asking me on Instagram. Sorry about that. I don't know who's calling my phone. Okay, let's see what else we got here. Okay, do you guys have any other questions for me before I disconnect? Yes, no? I have 9 minutes. 9 minutes. You have 9 minutes of my time. You can use this time to ask me questions. Okay, I'm just going to wait for everybody to okay, Joy says, how much is your consultation fee? It's $150. Okay, let's see. Did I miss anything here while I'm waiting for you guys to type? Okay, Chin on Instagram says, what is the waiting process after you submit your application? What application? So all applications are different, and what happens with each application is different. So if you can specify the application, I will be happy to answer you. Good morning, Orvel. How are you? Let's see what else we got here. Good morning, Kathy on Instagram. Once a person becomes a permanent resident, can they sponsor their mom and sister? No, they cannot. In order for you to sponsor your mother, or in order for you to sponsor your sister, you have to be a U.S. citizen. Green card holder of application via has been pending for over 2 years, and I have a VAWA case. Do I wait for USCIS to respond to a pending green card before putting in the VAWA? So, okay, so let me make sure I understand. So you're saying basically you submitted a marriage-based green card, which has been pending, and now you have a VAWA issue in your hands, and you're wanting to know, can you submit a VAWA petition? The answer is yes, you can submit a VAWA petition even though that case has been pending. Happy to discuss with you to see if you qualify and go over what the steps are. Okay, so the person is asking green card through marriage. What is the process? So the process, timeline with the green card through marriage is once you first submit everything, you get your filing receipts, and once you get your filing receipts, usually they'll schedule for biometrics. Once you do your biometrics, you get your work permit, travel permit if you applied for one, and then you get scheduled for an interview. If everything goes well in your interview, they will approve you. If they need additional information, they may request additional information. If they don't believe you have legitimate marriage, they will do what we call an NOID, which is a notice of intent to deny, and ask you for more proof and evidence of the legitimacy of your marriage. And if you do that, oh my goodness, what the heck? All right, guys, hold on one second. Can you guys on Instagram hear me? My phone is off the chain today. Can you guys hear me? On Instagram? Can you guys on Instagram hear me? Okay, somebody keeps calling me, and because I'm on Instagram on my phone, it keeps disconnecting my voice on Instagram. Somebody's asking, what if my husband decides not to show up for interviews? Okay, I give up. Now my sound is off because this person keeps calling me. Let me just see why they're calling me so much. Okay, guys, I'm actually going to get off live just because my phone has been ringing off the chain by the same person. Let me make sure nothing is going on. Okay, guys, I had fun chatting with you guys. I will try to be on live tomorrow later in the day. probably around like 11 a.m. So, or should I come at 12 p.m.? When do you guys take lunch? For those of you that work, yeah, somewhere between 11 and 12, I will come on live tomorrow. And, all of you just keep your questions. You can ask me tomorrow and I'll get to it. Okay. All right, guys. I hope you have a lovely rest of your day.